Good morning. A vital judgment which plays major role in career of the person for whose favor the judgment was delivered or whose favor the proposed scheme was implemented. At the same time, the other area of the populations may suffer ultimately without reservation, whatever it may be called. But one thing I want to share this judgment for this reason is that unless and until you understand what all are the procedures being followed, and every section segment leaders claims because they have some population to back him for reservation, additional inclusion, separate quota, horizontal quota, instead of vertical quota they want horizontal quota. All these things are politically managed and politically implemented, politically promised. This is a case AR 2023 Goha 353, State of Mizoram versus Mizoram Gorkha Sangh, wherein there was a permanent body for the consideration of inclusion of other caste in the other backward classes. So they say they are bound to follow the recommendation of the permanent body. Single writ petition was disposed holding that you are bound, state government is bound to implement. But however, division bench says no. You are, of course, you are bound to implement the inclusion of the Gurkha community. But however, if you are not accepting, you have to give reasons. Some fantastic judgment. But before that, for readers, I would like to show that this is Indira Sahani case, Union of India. 1992, 1993 SC 477, Indira Sahani case. That is most important case wherein the reservation policy, creamy layer, everything was introduced. They say that the Supreme Court has given direction in the year 1993 itself. Permanent body in the nature of commission or tribunal. We are considered that there ought to be permanent body to which complaint of wrong inclusion, non-inclusion of groups, classes and section in the list of other backward can be made. Such body must be empowered to examine the complaints of the nature and pass appropriate order. The advice opinion should ordinarily be binding upon the government. Where however government does not agree with the recommendation, it must record its reason. Therefore, even if any new class group is proposed to be included among the other backward classes, such matter must also be referred to the said body in the first instance. This is what they say. Therefore, finally they say, state government shall accept the recommendation of the body, and above the state government does not agree with the statement which is ordinarily binding, state must record its reason. Therefore, that's what they say. And they have also stated, you may also nature of commission also, the government of India and state governments have power to and ought to create permanent mechanism in the nature of commission for examining request of inclusion and complaints of over inclusion or non-inclusion the list of OBC and to advise the government. This is what they say. So you concentrate on this judgment. Even if you are not belonging to backward community, if you are belonging to SC or if you are belonging to richest population world community, other open candidates. It's all are there. Nowadays, but the problem was dominating procedures followed by the already occupied persons category. Of course, there may be some 50+% people are belonging to forward community, If they would have exhibited proper care and other things, we need not cry for reservation for backward community. But they not only occupied the post but also protect their men to be included, preventing others from reaching and occupying the post. This is still happening, whatever may be the reservation point. There ends the matter. Other one is, see, cross-examination. Not only criminal side practice, but also civil side practice also. Nowadays, we are facing lot of problems. Every judge is having innovative thinking, imposing, taking advantage of that they are later entry district judges and they have sufficient time also, do not have much cases, barking upon the young advocates, blaming, whatever it be, just they are behaving like class leader of the schools and college monitors, PT master, like that. But however, see, PW1 examined. When I proposed to examine PW2, I filed a proof affidavit, also a petition for filing additional document. The land judge called it for check and call on. Next date appearing, when the case was called, the judge says your petition is returned, and he says openly that I am not going to give any time you examine. Whatever it may be fate of the, but however, it is good for my client. Therefore, I examined, and judge says no documents marked. Not even allowed to mark whether I have originals or not, whether this is the document or not. This is somewhat dictatorship is being going on. What we could not understand. Family court, the entire things was argued. The judge openly said last hearing, stating that I will pass orders today or tomorrow, next hearing date. Suddenly, when the case was called next hearing, judge says, posted for enquiry date, other side not appear. What is this? What is this is happening in the minds of the judges? Whether this is one among symptom of COVID, new variant virus, God only knows. We can't do more than that. And before the High Court, same thing. The superior officers are not controlling the subordinate officers. Subordinate official simply imposing several problems. Similar repetitions were allowed or passed, but he says that was different passing clerk. I am not that passing clerk. What is this? Who is going to check? And in one Facebook status says all family courts should be properly, thoroughly checked. This is what I have already told. So many things are happening in family court. Let the vigilance registrar to inspect. Then finally, our acting Chief Justice, he was fantastically acting as Chief Justice, balancing the entire administration equally. But now he has been transferred. Okay, he is having left 1 month, that vacation is being followed. Let him retire peacefully at the place where he is being transferred. And our new Chief Justice will be Maharashtrian. After a long time, M.N. Chandrukar, one Maharashtrian is being posted. One more judge was appointed as Chief Justice of India as a Tamil Nadu, but he was not Maharashtrian, he is a Gujarati. Therefore, the Maharashtrian people, somebody says he was prevented from elevated as Supreme Court judge. All these things are happening. It's not that despite their nobility of holding the post, all are exhibiting their nobility. Whatever it may fate of us, let us watch and pray. Best wishes.